Welcome to the Inside Man YouTube channel from J&W Solicitors. Please subscribe to the channel, like this video, and keep the conversation going in the comments section as well. Now, with the Commonwealth Games about to start in Birmingham very soon, businesses need to be very careful about ambush marketing. Lucy Marlow is a senior associate solicitor within J&W's intellectual property department, and Lucy has a particular interest in sports intellectual property as well. So Lucy, what is ambush marketing?
So ambush marketing is basically when an entity tries to gain an association, typically with big ticket events, to promote their business, but they haven't paid for the rights to do so. And what that means is that the rights holder, so for example, the Commonwealth Games or the Olympics, they can come after you as an infringer, claiming that you have infringed their rights. Typically, they'd be relying upon their intellectual property rights, such as their trademarks. Good examples of this are, in the case of the Olympics, large-scale example, when Dr. Trade Beats, they gave out their headphones to the athletes, but they hadn't paid for the rights to do so. So they gained an association with the Olympics. Many people would have thought that they were official sponsors in some way, but they actually were not. Smaller scale examples can be when local businesses might repost official content. For the Commonwealth Games, Birmingham businesses might think that it's okay to, use the trademarks that the Commonwealth Games have, such as Birmingham Commonwealth Games. We're bringing it home. The words "bringing it home" are registered as a trademark by the Commonwealth Games. And if companies do that, they could be find themselves on the wrong side of the law here.
There'll be businesses in Birmingham and around the country getting really excited about the Commonwealth Games. So what can they do?
Obviously, it's a great commercial opportunity to these businesses, but any business seeking to gain an association with the Commonwealth Games needs to be very careful. So firstly, I'd recommend that they take legal advice. They should get in touch with intellectual property lawyers such as myself, and we can talk them through what they're proposing to do and whether or not it falls on the right side of the law. Some basic points: don't use official trademarks. Be careful of high-risk themes such as using the words Birmingham and the Games. Obviously, don't repost official content. But it's quite important that you think about potentially putting in place an anti-ambushing marketing policy within your organization, because, often posts can be made on social media and those are they could be picked up by the rights holder, and you could find yourself receiving a cease and desist letter from the Commonwealth Games.
You mentioned a letter there, Lucy. What would happen in the worst case scenario then if a business did receive a cease and desist letter? And also, is it going to hit the business in the pocket?
So on the hitting the party in the pocket point, well, the rights holder can come after you for various claims, but in particular on the IP side, they can come after you for financial compensation arising by virtue of your infringement. And typically the way that's assessed is, if a license had been in place, what would the fee be that attaches to that? So it's been very hypothetical, looking towards what a hypothetical willing licensor, the Commonwealth Games, and you as a licensee would have agreed if you'd have done things properly. And lots of factors need to be taken into account there, such as the period of infringement, the nature of use, how much, the licensee would have gained from such use in question. And it's all looking towards, well, what would have been a reasonable sum? And that's where really lawyers need to take a look at the case and assess the case and give you an indication as to where you stand on that point, so that a reasonable deal can be reached. Another thing, going back to if you do receive a cease and desist letter, what should you do? Well, first of all, speak to a lawyer such as myself, and we can look into the nature of the infringement that's been alleged, see what the merits are of that, and see what flows from that. So going back to the point before, what would be an appropriate degree of financial compensation, and also what action needs to be taken. So, for example, should you immediately remove the post in question, given the amount of risk that's associated with that post? And then we can look into trying to bring you to reaching a commercial deal that's suitable given our assessment of the nature of the infringement, your commercial objectives, etc.
Thank you for your insight, Lucy. And if you'd like to speak to Lucy for more information, or if the worst case scenario does happen and you receive a cease and desist letter, you can contact Lucy, insideman @jmw.co.uk, or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel from JMW Solicitors for the latest legal news and insights and information. I'm Dominic Walker, JMW's Inside Man.